Well, welcome everyone. This is our monthly Maddy Associates speaker series, Lunch and Roundtable. We are very fortunate today to be joined by David Carrillo, who is a lecturer in residence and the executive director of the California Constitution Center at UC Berkeley. Let me tell you a little bit about David. He's been there, by the way, since 2012. The center is devoted to developing a scholarship concerning the California Constitution and the California Supreme Court. And by the way, when we were going to do a kind of a review of the California Supreme Court, I went right to the California Supreme Court and I asked them, who is the best person I could have to talk about what's happening in the last term of the court? And they said, oh, we know exactly the guy, David Carrillo. And so I was very fortunate that he said yes to join us today. So we've got literally the court's recognized expert on what's happening in the court this last year. So, Dave's background is varied and interesting. He spent 16 years in practice, a lot of that working for the state and for local jurisdictions. He was a deputy attorney general, for example, with the California Department of Justice. He also did commercial litigation as an associate in private practice for a while. So he knows both the private and public sector when it comes to the law. In 2019, California Governor Gavin Newsom appointed him to a 4-year term on the California Law Revision Commission, where he's serving currently as the vice chair. So I don't want to take up any more of David's time because I know you want to hear from him and not from me. So with that, I'm going to turn it over to Professor Carrillo, and thank you so much for joining us today.
Thank you for inviting me. It's really a pleasure and a privilege to be here. I should note for the record that the list of people who probably would be appropriate for a segment like this is very short. So when you say that the court recommended me, I'm obviously very honored by that. But there's really only, I don't know, maybe 3 or 4 people who on a regular basis seriously look at the California Supreme Court. Obviously, it's very different from the U.S. Supreme Court. It's the other way around. You can't swing a dead cat without hitting 5 people who are experts on something about the U.S. Supreme Court, which is a little sad, especially, so my thing is I study state constitutional law, specifically California's. And, so what those of us who study state constitutional law, it's always a little sad to us that it's such a small field. And we all kind of know each other, just like the 3 or 4 people who look at the California Supreme Court. It's a small club. We all know each other.
I want to tell you, David, when I was in law school, way over on the other side of the country at University of Wisconsin, we always studied, national trends in the law, and we look at the majority of states, minority of states. Oh, and by the way, California.
Yeah.
It seemed to be in its own category.
Yeah, that's definitely true. We're the tail that wags the dog in a number of broad categories, the economy, media, the law, obviously. And there's been a number of instances historically where California law has moved in a direction, and the U.S. Supreme Court has caught up and gone with California. A couple of times they don't go with us. Sometimes they've overruled us, but as often as not, California courts and California constitutional law have been leaders in some pretty significant areas of the law over the years. But here we are in the second year-ish of the pandemic, and so I was going to talk a little bit about what the past year has looked like for California's judicial branch in general and the California Supreme Court in general. And it's been a bit of a mixed bag. Some things are better than I expected, and some things are not as good as I hoped. One big takeaway from the past 2 years is just how much work the Judicial Council and the Chief Justice in particular put into keeping the trains running in the judicial branch, and more importantly, how successful they were at doing so. There's been a little bit of news coverage, so you might have heard about this, but there were a few instances where Governor Newsom delegated emergency authority to the judicial branch, or the Judicial Council specifically, to do things that were necessary to adapt to the pandemic. And the Judicial Council really ran with that authority very successfully, I think. And so that leads to one of the big takeaways, which is that, so we've all had the experience of dialing in with an ancient, practically rotary phone system to call into oral argument or law in motion or something like that. And, I've been out of practice for a little while, but, back in the day, not only was it horrible, but also everybody in the courtroom would sort of be laughing at the poor schmuck who was on the phone, who, you could barely hear him. And the judge was kind of rolling his eyes. And, it was always, everybody knew it was always better to show up in person because there were huge disadvantages to being, the one joker on the phone. And I think that things have really switched now, particularly from the Judicial Council's perspective. They really leaned into remote appearances, and they did it primarily from the perspective of securing access to justice. During the pandemic, obviously, that remote appearances were the only way to give people access to the courts. And so, you didn't see the Judicial Council doing it sort of grudgingly or in limited ways. They really leaned into it and embraced it with both hands and open arms. And I think that's one of the big takeaways is that not only did that work out very well in terms of giving people access to the courts during the pandemic, but I think going forward, that's going to be one of the big takeaways from the pandemic is that it's fundamentally going to change the way people access the courts. Even as practitioners, everyone over the last couple of years has gotten used to doing things like this on Zoom. And now that people are so accustomed to it, I think it's just going to become much more of a regular part of the process. So the days of having to drive, 100 miles for what's supposed to be a 5-minute court appearance, and it winds up getting continued anyway, that, was just a huge waste of everyone's time and billable hours. I strongly suspect that that's going to be a thing of the past moving forward. The Chief Justice was doing a segment with PPIC recently, and she made the point that they found that it's actually better in some instances in juvenile dependency cases and family law matters. It's actually better to have things remote like this because they found that when they have to have the kids talk, it's a lot more comfortable for the kids to be talking on their iPad screen with a judge than schlepping them down the court, and it's very formal, and the kids are terrified, obviously. So overall, remote appearances, way more successful than anybody would have thought, much more likely to be a significant part of practice in the future. And in terms of access to justice, it turns out it's actually better in some instances. So that was one of the good things, or, one of the big positive takeaways of the pandemic. Another big positive takeaways is we have a new justice on the California Supreme Court, Justice Jenkins, joined in December 2020. I think he's universally regarded as amazing. So he's really going to be, I think, a great presence on the court. It's too early to say how he's going to work out as a justice of the California Supreme Court. He obviously has a very long judicial record. So on the newest member of the court, I guess you could look at it two ways. We either know a little bit about Justice Jenkins, or we know a lot about Justice Jenkins. We know a lot about him from his past time on other courts. But he's only written 2 majority opinions so far this year. So
can I interrupt you for a second? Yeah. A lot of times you hear, for the U.S. Supreme Court, it's a 6-3 conservative majority.
Yeah.
What would you say for the California Supreme Court? Obviously, it's going to be not conservative, it's going to be liberal. What would be the breakout there? And I know there's going to be a new court justice appointed, but assuming it's going to be by Newsom, so assuming it's going to be a person who's going to be left of center, what would you say the breakdown is on the California Supreme Court?
That's actually a very interesting question. And my center has been taking a very close look at that since Jerry Brown started appointing people to the California Supreme Court, going on 5-10 years ago now. And I think the short answer is that frame of reference just does not apply to the California Supreme Court right now at all, period. There's no liberal wing, there's no conservative wing. I can unpack it, but the top level answer is I don't think that frame of reference that everybody's so used to applying to the U.S. Supreme Court, I don't think it applies to our court at all.
Well, why would you say that?
I think there's a few factors.
I think some of our conservative part of our audience would say, yeah, it's because they're all liberal.
That's one way of looking at it, but I think the data provide a very significant wrinkle to that that calls that into question. So up until very recently, on the surface, it looked like there was a very easy dynamic that you would have expected if our court was going to look like the U.S. Supreme Court, when there were 4 justices that had been appointed by Jerry Brown and 3 justices who were more senior, who were holdovers from and had been appointed by previous governors. So there was a lot of press coverage at the time when Jerry Brown got his 4th pick, and people who look at the California Supreme Court were looking for that. And so we waited a couple of years and we took a look at the data. And very consistently, the data ever since it's obviously the majority's obviously changed, and it's I guess from a conservative point of view, it's gotten worse. But the bottom line is we've never seen in the data any indication of a 4-3 split, a 5-2 split, a conservative liberal split. It just doesn't show up in the data at all. In fact, it's so rare for there to be 4-3 splits that they're almost outliers in the analysis, and you should probably just discount them. So even with those, or if you discount those, the huge takeaway from the data, and again, it's very consistent over the years, is that this court operates by consensus. If you compare their unanimity rate with the U.S. Supreme Court, it's far higher. It's 20 or 30 points higher. Our court's in the 90th percentile consistently year after year for unanimity, and that's
So you're seeing a lot of 7-0 decisions then?
Say again?
You're seeing a lot of 7-0 decisions.
Lots of 7-0 decisions, yeah. There's one caveat there, which is that Justice Liu likes to write separately. So he'll vote with the majority, but then he'll write a concurring opinion. Sometimes he writes a concurring opinion to his own majority opinion.
That's interesting.
Yeah. So I guess there's a couple of ways to look at that. I look at it as it's a court that just fundamentally operates on a different model from the U.S. Supreme Court. There are a number of obvious reasons for that and some other less obvious reasons, but like the upshot is it's very hard to get away from the conclusion that the court just has a different culture, a different mode of operating, a different way of approaching its decision-making process. Like however you want to phrase it, it's just different. And
if you went back, 30, 40 years ago when we had Republican governors, and they were appointing justices, would that still be true? Would they still voting unanimously, Republicans and Democrat appointees, or was it more like the U.S. Supreme Court where there was this kind of conservative liberal split?
The short answer is if you take the long view, and I've done that. My center was part of a 100-year voting pattern.
Yes, I would
analysis.
say you've done that.
Yeah. So we've looked at it from a variety of perspectives. We've taken the long view. We've taken recent history and analyzed that. We've looked at non-unanimous decisions, voting patterns, partisan behavior by the justices. And without getting into 100 years worth of data, I think the top level takeaway is that there's a pendulum swing dynamic that's pretty apparent. There was an early period where there's very little partisan behavior on the court, and it looked kind of like the court we have now, where it tend to operate more on consensus, and you have a lot more unanimous opinions.
And this was 100 years ago.
Well, that ended around the 50s.
Okay.
I think Phil Gibson was Chief Justice at that point. I hate to say this, but you kind of have to blame the 60s.
Don't we always?
Yeah. So what? And here you I think you actually can compare the U.S. Supreme Court and the California Supreme Court because they behave fairly similarly, broadly speaking. So what you have is on both courts for a fairly well-defined period of time in the 60s and 70s, where the courts swung much more liberal than they had in the past. And then you have a counter reaction again on both courts, and again in approximately the same time schedule, where they swing the other way, and there's a counter reaction to that, and the courts both go much more conservative. Where they diverge, though, is in recent history, where as a result of the recent appointments that you have, the U.S. Supreme Court has continued its trend of being more conservative, and it's arguably as conservative as it's been in quite a long time. California Supreme Court is, I think, arguably has more equilibrated, and now it looks a lot more like it did before the 60s. Back in the Phil Gibson and before times. So again, the courts behave differently. They match up for a period of time. It's around 40 years where there's this huge liberal swing and a huge conservative counter swing. And the U.S. Supreme Court sort of stays going in that direction after Justice Rehnquist. And the California Supreme Court, I think, has kind of come back to a median. So to your point that, one way of looking at the current California Supreme Court is, yeah, of course, they all agree with each other because they're all liberals. Well, that's not exactly true. Justice Chin was a fairly conservative person, and he wrote some fairly conservative opinions, took some fairly conservative positions. Justice Corrigan's a former prosecutor. I think most people would hesitate to call her a liberal. Same with the Chief Justice, also a former prosecutor. So that was part of the reason that a lot of people, a few years ago were looking for this 4-3 split, because you had arguably the Chief Justice, Justice Corrigan, and Justice Chin, who could have, or people were expecting them to form the court's conservative wing, and they didn't.
Wow, that's really interesting. The dynamic, the difference between what's happening in the U.S. Supreme Court and California Supreme Court.
Yeah, it's night and day different. And from my perspective, I think that's good. So in the 100-year study that I mentioned, we were particularly looking at non-unanimous decisions, and we were looking for patterns of partisan voting behavior, and we found it. We found it glaringly obvious for a period of about 40 years. Sometimes it was.
And when was that? The 60s through the like 2000 or?
Yeah, it starts to taper off after 2000. So our study period ended in 2011, I think. So right when the current Chief Justice was sort of putting her stamp on the court, so to speak. Chief George was on his way out, and then Justice Cantil Sakauye had just joined the court. So anyway, so you start to see a pattern, the pattern of partisan behavior. It starts to get a little muddier towards the end of Chief George's tenure. Janice Rogers Brown had left the court by that point. So it kind of peters out, and to the point where today, partisan voting behavior it's actually very difficult to detect because the unanimity rate is so high. So if you're looking for partisan voting behavior, you have to look at the non-unanimous decisions, obviously, because you're trying to figure out, who's voting which way on what kind of case. And if the court's decisions are 90% unanimous, it gives you a very limited data set to actually, be able to detect partisan behavior. So for example, we've been looking for 4-3 decisions over the past few years. I think there's less than 5. There are years where there are 0 4-3 decisions. I think there were none last year.
Wow. I apologize for asking you so many questions, but
no, it's helpful.
It's really interesting. I'm just wondering, and if this is an unfair question to say, we don't know, but what about the lower courts, like the appellate courts? Did you see the same thing happening there?
I don't know that anybody's looked at that because the data set is vastly larger.
Yeah, I can imagine.
That's beyond my pay grade, I'm afraid.
you were talking about the things that have happened in this last term, and what COVID brought about, and how this term is with the new justice coming on board. Any other general takeaways about this last term?
Yeah, so this is in the not great news category, which is that in an ordinary year, and the last couple of years have been far from ordinary. In an ordinary year, I look for about 80 decisions on average from the California Supreme Court. It's been trending down in the last 20 years or so slightly, but somewhere around like 80-ish decisions that would be a normal year these days. Here in the pandemic, we only have 49 decisions so far, as of end of October here in 2021. So they're off pace. I'd be surprised if they hit 80 opinions by the end of the year, and I don't think they're gonna. I think we can blame the pandemic for that mostly. And there's also the effect of Justice Jenkins joining the court. Anytime you have a new justice taking over chambers, it's pretty observable that there's a lag time for that justice to gear up and take over the cases that were sitting on the desk that the new justice occupies. So like even Justice Liu, who's a very prolific writer, I don't think he filed his first majority opinion until he'd been on the court for about 8 months. So it's not a big surprise that we've only seen 2 from Justice Jenkins so far.
Yeah, it's affected everyone, no doubt. So any other takeaways for this year? General takeaways?
General takeaways. So when I was looking at the 49 cases, one thing that jumped out at me was that there was one case where the court granted review on its own motion, and that seemed to me to be unusual. So I took a look at it, and it turns out it's not all that unusual. In the last 34 years, on average, the court grants own motion review around twice a year.
Can you explain what that is? The court makes a motion to itself and it rules in its own motion?
Yeah. So,
seems a little Star Chambery.
It might seem that way, but it's actually not, especially given how rarely they do it. So before I started looking at OMGs, own motion grants, it's a little funny. Before I started looking at that, I knew that a couple of general things. One is that the overwhelming majority of the court's docket arrives there either from them granting review in a case or because it's an automatic capital review. And I knew that there were a few, kind of outlier like edge case categories. Sometimes it takes original writ proceedings. It does have a few original jurisdiction categories of cases. But I actually didn't know about own motion grants. So I spent a little time looking at it. And the other big thing, that anybody who does appellate law knows off the top of their head is that the rules of court give the appellate courts, and particularly the California Supreme Court, very broad discretion about transferring cases, denying reviews improvidently granted. California Supreme Court can grant and hold cases because they're waiting for a couple of other things that are related to come to fruition, things like that. And so the authority to do own motion grants or review, it's included in the same rules. It's 8.512 sub C1 authorizes the court to grant review even if no petition is filed. And C2 and D give the court discretion to deny petitions and then do something else, review it on its own terms, grant and hold, or transfer it or whatever. So it's, own motion grants are all part and parcel of the court's general rule of court granted discretion to manage its own docket in the way that
it seems like a lot of power that the court has.
Well, you have to remember that the California Supreme Court is not a court of error correction. It's a court of discretionary review, primarily. I mean, there are a couple of things that it's required to hear. I mentioned it has a couple of original jurisdiction things. Public Utilities Commission appeals, it has original jurisdiction over. And the other, like the big category and the obvious one is capital appeals, which go directly to the California Supreme Court. They bypass the Intermediate Court of Appeal, and California Supreme Court has to review them, which we can come back to in a minute. It has a very big effect on its docket. But so outside of those mandatory or original jurisdiction things, the rule is the reverse. The court has discretion over everything else on the rest of this docket because it's not a court of error correction, because it's only a court of review. So it's the rule or the expectation is actually in the reverse, that you have no right of review in the California Supreme Court. You shouldn't be expecting them to grant. In fact, given that they only grant, I think it's like 3 or 4% of every petition, out of all of its petitions that it gets on an annual basis, it only grants around 3 or 4% of them. So with numbers like that, the expectation should be that you're probably not going to get the California Supreme Court to look at your case.
Wow, that's pretty interesting. So there were some other things we were going to talk about, and we're actually going to be taping a program after this for the general public. Just some things there. You were talking about, in addition to that particular issue, which I thought was pretty interesting. We're going to talk about some other things. Let's see here.
We were talking about Justice Cuellar leaving.
Yeah, Justice Cuellar leaving, and what impact that's going to have. You were saying he was really active.
Yes.
You normally think when people, what is that, like a comet that's flaming, or star that's flaming out at the end, and all of a sudden is really productive. I mean, normally on your way out the door, you're probably toning it down.
Yeah, I hope he's not flaming out. If anything, his star is rising.
There you go.
He's on to even bigger and greater things than being a California Supreme Court justice. But yeah, I think your phrase when we were talking about earlier is that he's running through the tape would be the track metaphor,
right?
Which is fantastic. So I track how many opinions, especially majorities, each justice writes, on a year-to-year basis, and so up until he retired, Justice Chin was usually right up there with Justice Liu. Those two were far and away they had the highest output in terms of opinions out of all the 7 chambers. Justice Cuellar was not in that group, but here in his last year, he's in second, right behind the Chief Justice for most. Yeah,
that was, you were saying that when we were speaking earlier. You were saying the Chief Justice has written a lot of opinions this year, and
yeah, she's in the lead.
Surprising when she has all those administrative responsibilities for the court.
Right. Yeah, she has 20% of the decisions so far this year, and that is a little unusual. And believe me, I am not saying that in any way to disparage the Chief Justice's work ethic. In fact, quite the opposite. She tends to not be the opinion writing leader among the 7 justices because she has an enormous additional tranche of administrative responsibilities that the other 6 justices don't have.
When you said what are her administrative responsibilities? Not just the California Supreme Court; it's all the courts of California.
She's the head of the California Judicial Branch, which is one of the 3 branches of the state government. She has told a story a couple of times in public, so I'm not speaking out of turn. She's told this story about she went to the legislature, I think in her first year as Chief Justice. She does this annual State of the Judiciary thing, and she also talks to members of the legislature about the judicial branch budget. And she went there and she was astonished at how many members of the legislature didn't get the fact that the judiciary is its own branch of government in California. And they just assumed that like she worked for the governor or somebody. Like they just had, they had no idea. So yeah, so, we have three branches of government. The judiciary is one of them, and she's the head of a whole branch of government. So,
And there's something called the Administrative Office of the Courts, AOC, and is she in charge of that? There is an who's in charge of that?
Yeah. So there's been a little bit of a rearranging. And so now my understanding is everything is underneath and run out of the judicial branch, which she is the chair of. So in addition to, her administrative responsibilities as head of the California Supreme Court, she's also head of the judicial branch, which in turn, she's the head of the Judicial Council, which in turn is at the head of the judicial branch. So she has two major organizations that she's responsible for running. One of them a little bit bigger than the other one, which is not surprising that it doesn't leave much time for sitting up late at night and writing brilliant legal opinions by candlelight, which she does do, just not as much as everybody else.
And there have been in the last few years some disgruntled lower court judges who've been disgruntled with the Administrative Office of the Courts, and I'm sure she's had to deal with that as well. Yeah,
that's actually very common. Back in the day, in Chief George's day, the big issue was trial court funding, money. There were a couple of big initiatives that there was a case management system that they tried to get off the ground, and it cost a lot of money. And Jerry Brown cut, I think, like $500 million out of the judicial branch budget, cut it in half one time, not that long ago when he was governor. So money's been kind of a, ongoing perennial point of contention in the judicial branch. It tends to be chronically underfunded by the legislature. So people are sort of scrambling for scarce resources and fighting over a pretty small piece of the pie. And obviously, in the last couple of years, the fact of having to deal with pandemic chaos, just, that'd be like a whole nother level of administrative responsibility the chief would have had to deal with. So it's kind of amazing that this year, in the second year of the pandemic, she's written more opinions than anybody else. That's frankly astonishing.
Let me circle back. We were saying, the use of Zoom and those kinds of, video conferencing to do court things, and with limited resources, will that make them more efficient so they'll be able to handle more with less?
I'm hoping so. There's a video of the PPIC thing. So if you want to read and hear, watch the whole thing, I welcome people doing that. But one of the big takeaways for me was how excited the chief was about the possibilities for remote appearances, sort of across the board. So one of her big initiatives that she cares about and has tried to advance during her tenure is access to justice. And I think she was just as surprised as everybody else that, one of the silver linings of the pandemic was everybody sort of grasping and leaning into the advantages of remote appearances. It saves everybody money across the board.
Right.
People don't have to drive. They don't have to take days off work. Things arguably move faster. Like doing jury trials over Zoom is that seems to be like the one bridge that nobody wants to cross. I think a few courts have tried it and it's been disastrous. But for law in motion or anything short, arraignments, recalendaring your stuff.
We've actually had her on the program a couple of years ago. She's very involved in civic engagement. So she's been doing this for quite some time. I do a lot of work as a federal mediator and an arbitrator. Arbiter is more akin to a judge. And I do cases in Texas, for example. And I'm trying to convince, this is for the Border Patrol and the U.S. government, to save money. Why fly me out there and spend that? Just do it via Zoom. And it's worked during COVID, but I'm seeing they're going back. Why don't you come out to Texas? I'm like, I'm trying to convince them, we can save everybody a lot of money by just doing it virtually. You think the court, you think that's really going to be something that happens? We have these hybrid models where you'll see a lot of court cases maybe handled with a judge, sitting in a room by himself while he's watching people on a screen.
Yeah, I both think that's going to happen more, and I hope it does. So let me put it in my own context. So this semester I work at the University of California at Berkeley, and so they've come back to in-person classes, and so I've gone to a hybrid model where I have this giant TV on a stick that I roll into class, and I plug a laptop and a camera into it. And I've had all kinds of amazing people to beam in, getting people to schlep over to Berkeley to do, an hour or whatever for a class. Like people would do it before the pandemic, but it was a big ask, and it was a logistical pain in the butt, especially for, like the chief judge of the Sixth Circuit, Jeff Sutton, or the chief justice of California. But now I can have those people beam in directly from their chambers. It costs them only the amount of time that they're actually on, and then they can go right back to, administering justice. It's fantastic. I've had more and better speakers in my class than ever before. I absolutely love it. I'm sticking with it. And so I can easily see the courts just having a big TV on a stick at the plaintiff's table and a big TV on a stick at the defendant's table. And the judge just talks to two TV screens, like remote telepresence rigs, and it'll, we're all used to it now. It's going to be just like it was before, if not better, because you don't have to go down to the courthouse.
Yeah, the top organization of MIRE, the National Academy of Arbitrators, has done a review with this with the Federal Mediation Conciliation Service, and they've said, not only do we approve of this, we actually encourage you to do it. And by the way, if the parties don't like it, you as the arbitrator can order it. Can tell the parties, no, this is what we're going to do, which is kind of interesting. The problem in this context, in my context, is the arbitrator is chosen by the parties. So if you do that too much to one party, they just see your name on the list next time. We don't want him.
He's the guy who likes to do it on TV. Forget him.
So, yeah, a little different. Does the court have that power to say, we're going to do this virtually?
Yeah, yes and no. So there already are provisions in the rules of court for remote appearances in some contexts, and some of it exists by local rule. Again, it's been a while since I was doing this, but when I was in practice, you always had to look up the local rules. Like some people, would allow it, some people wouldn't. Some people, some courts would limit it depending on the type of case. You always had to look up because everybody had a different vendor for how they did it. And so you had to figure out the conference call system. And then eventually everyone went to a court call as kind of the default standard. And I think Zoom, obviously is becoming the default standard now.
When I practiced law 100 years ago, we used to have short calendar, right? Kind of, you go to the court and find out where your case is on the docket, what's happening. And you'd go to, let's say you're representing 3 clients. And so you got to be there for each client. So you're billing each client. It's almost like quadruple or, triple billing, which was not good for the client, good for the law firm. Can't do that anymore with this. This is going to be, log in, log out. It's going to be a little bit different, maybe. I want to get to some of the decisions by the court.
Sure.
I guess the criminal cases had a big part of the court's docket this last term. What can you tell us about the criminal and this court case decisions by the court last term?
This year it's been very interesting. So when I was looking at the cases, there were 2 things that jumped out at me. I would characterize it in 2 ways. The cases that have been on the docket this year are interesting, both for what you see a lot of and what you don't see very much of at all. What you do see a lot of is crime. Criminal cases are always the single largest subject matter tranche of the court's docket every year. It's just reality. Part of that is driven by the fact that the court automatically reviews every single capital verdict. It's mandatory, non-discretionary. So this year, crime in general, including automatic appeals, it's over half. I counted 29 out of the 49 were some kind of criminal case. The capital cases were 13 out of the 29. So it's 13 capital, 17 non-capital general criminal cases. So crime featured pretty heavily on the court's docket this year. It always does. The thing that did not feature on the court's docket this year, which was a little surprising, was emergency pandemic restrictions. My colleague David Ettinger, who's one of the other small group of people who looks at California Supreme Court, he publishes at the lectern, and he's at Horvitz and Levy. He pointed out how interesting it was that there's at least half a dozen instances of a litigated pandemic emergency restriction that made it to the Court of Appeal and was presented for review by one means or another to the California Supreme Court, and they declined review in every one of those instances. That was particularly
these are cases like what, like mask mandates or
all
school requirements, all the stuff you're hearing in front of school boards where people are going crazy and they're not getting reviewed by the court, by the Supreme Court.
Yeah, so it was interesting for a few reasons. One is that by contrast, there were a couple of high-profile examples of the U.S. Supreme Court weighing in, particularly on restrictions on churches and religious observances. So it was obviously they were on what's called the court's shadow docket. They were non-merits decisions, I guess you could call them. But there's at least two instances where I can think of where the U.S. Supreme Court weighed in. Like, there's two cases I know of for sure, and they were specifically on Governor Newsom's pandemic emergency restrictions. And I tried to figure it out, and David Ettinger couldn't think of any either. Neither one of us could find a single instance of the California Supreme Court weighing in on any of those emergency restrictions. It all got handled by the California Court of Appeal or the Ninth Circuit.
Too hot of a potato to handle for the court?
No, I wouldn't characterize it because they've taken plenty of hot potato cases over the years. I don't know, but if I had to speculate, I would say that, so I mentioned earlier, they're not a court of review. They don't sit, or they're a court of review, not a court of error. So they don't sit to look for instances of the Court of Appeal getting it wrong and, running around playing whack-a-mole. So ordinarily, even if the Court of Appeal got it wrong, that's not a reason for them to take a case. But in this instance, I'm familiar with some of those cases. One of them, my center was amicus on. So I would speculate that the Court of Appeal and the Ninth Circuit didn't get them so wrong that the California Supreme Court felt like they had to step in.
It's interesting. So criminal cases, big part of the docket this term. There were a few labor cases too.
Yeah, quite a few. That was when I was breaking them out into subject matter tranches. Labor was the only other subject matter that had enough cases that it was significant. There were 8 of them, and then everything else had like 1 or 2 things.
As a labor lawyer, I go, yay.
Yeah, and I thought that was interesting. Like, it's certainly so. One of the little groups of cases that I identified was public works and prevailing wage, and that was very obviously an instance where the court sort of gathered several cases that were very related in terms of the issues they presented. And the court consciously said, okay, we're going to hold these cases and we're going to decide them basically all at the same time. It does do that sometimes.
Can you explain to the folks what is prevailing wage, a little bit of the history behind it, and what it means for public sector agencies like cities and counties and school boards, and why they complain about it so much?
I will, but let me make my other point first, which was even though there are instances like the prevailing wage thing I'm about to talk about, where you get 3 cases that are very clearly decided together as an intentional group, that's I don't want to say it's unusual, but that's less common than cases coming out in an apparent group when it's actually random. They just happen to all be, sort of at the same point of the process, so that they wind up coming out at the same time. So even though there were 8 employment decisions that came out, I do not think that it's the case that the court said, okay, this year we're doing employment, and next year we'll do water law, and then the year after that we'll do, I don't know, construction or whatever. I don't think they look at their docket that way in general. But there are exceptions, like, the 3 public works cases that came out. So the idea behind public works prevailing wage law was that, obviously the government has more control over what kind of laws and policies apply to things that the government does rather than things that private industry does. So we do have a minimum wage that applies, across the board, and that's kind of the floor, but you can go upward from there and impose greater controls on non-public types of work. So stuff that the government is doing. So if the government decides to, I don't know, build a dam or whatever, that is a public work, and they're going to contract that out. And because it's a government project, the government can require the contractors that hires to build the dam to pay a particular prevailing wage. And that may very well be higher than, not just the minimum wage, but the industry standard in that area for dam building. I don't know if there's a guild for that, but whatever whatever the going rate for dam building is. Yeah, because it's a government project, they can require you to pay, more for that. And there's some good reasons for doing that. You want a quality dam, paying cut rate wages will get you a not quality dam and it'll explode and everybody will drown, so there's a quality control aspect to it. There's providing good jobs. Like you mentioned that it has a historical antecedent that it came out of, the early, sort of work products depression
It
era.
was part of the New Deal legislation, and as a way to, it's just like the National Labor Relations Act allowing workers to form unions. The idea being that if we gave workers more money, i.e. forming unions, they can negotiate higher wages, or created prevailing wage where they can get paid more, they will then spend more, and that will be a way to stimulate the economy.
All that, yeah.
It's Keynesian economics.
Yeah, all that. Yeah, and leaving economic debates aside, that was the rationale, and it's still around. So the reason you have these three cases grouped together is because one of them presented the question of whether the key term is whether something is a public work, and if your project is a public work or the function that the individual employee is performing falls under public work, then you're entitled to the prevailing wage. If it's not a public work, or the work that you're doing on the project doesn't fall within that definition, then you're not entitled to it. So it's all about what side of the line you fall on. So one of the cases was a really good example of, okay, this is definitely a public work, and this person is entitled to a public wage, to a prevailing wage. The other case was, this is a really good example of, this is not a public work. So two of those cases together are really good examples of, this is what it looks like when it is, and this is what it looks like when it's not. So they're good counterpoints to each other. And the third one was a certified question from the Ninth Circuit. So you have these three cases that all come out at around the same time. Justice Corrigan wrote all three of them. And so each of them presents like a different facet of the same thing. So you read all three of them together, it's a really good explanation of, okay, this is what a public work is. This is when you get a prevailing wage and when you don't.
Yeah, and by the way, we did a program a little while ago about the most influential people, non-elected people in state government. And consistently in the top 10 is Robbie Hunter, who's head of the California Building and Trades Council. The construction workers that really care about prevailing wage. And so he's very influential in terms of state government, what happens. You also mentioned to me, we were talking earlier about some important decisions. One you talked about was Brown versus USA Taekwondo.
Yeah.
What was that case about?
It's an issue that's been in the news a lot recently. It's about the facts of the case concerned minor student athletes who alleged sexual abuse by their coaches, which is terrible, obviously. The facts of the case had very little to do with the reason that the case is important for lawyers, because the legal issue that the court resolved it's a tort law issue, and it's about the public policy analysis from Rowland versus Christian. So I mentioned earlier, the California Supreme Court tends to take cases for one of two reasons, sometimes both. It's either a big issue or there's a conflict among the Court of Appeals. And Brown versus USA Taekwondo is arguably both of those things. The Rowland versus Christian public policy factors, it's a pretty important issue in tort law, and there was a dispute among the Court of Appeals about how to apply them. Unfortunately for the student athletes, the ultimate resolution of it was that the Rowland factors are not used to expand the category of people who owe a duty. It's the other way around. Those factors are used to limit the class of people who have a third-party duty. So it didn't come out very well for the student athletes.
Yeah. By the way, we're going to get to the folks' questions in a second. Feel free to put them on the chat. I see Victoria has one question. We'll ask that and others as they come in. Let me ask you one last question before we open up to folks. And that is, you also mentioned something about the Humphrey decision. Can you talk a little bit about the Humphrey decision?
Humphrey's huge. It's for a number of reasons. It's the banner decision this year. It's Justice Cuellar's swan song. He wrote it, and it's not just the biggest decision of the year. It might be the biggest decision that he wrote in his entire time in the court. Humphrey's about bail, and bail is important in general. Obviously, for anybody who gets arrested, the ability to post bail is frequently the difference between being able to successfully defend the charge versus languishing in jail because you can't post, and you stay there long enough that on the cost benefit analysis, it makes sense to just plead for credit for time served. So the inability to post bail is very closely tied to significantly encouraging people to just plead out. just so they can get out of jail. So that's on the, like the public policy and practicality side of it. But on the California con law side of it, there's been this lingering, languishing confusion between two provisions in the California Constitution's Article 1, Section 12 and 28, and they both concern bail. They both got affected by several different competing or conflicting ballot propositions, and so the end result was it was unclear to courts whether bail was something that a person had a right to, and denying bail should be only done in very limited circumstances, or whether public protection favored courts routinely denying bail. And those are two very different ways of looking at something that's this important. And this issue's been floating around kind of for a while. California legislature tried to deal with it back in 2018. The voters overturned the statute with a referendum. So now, so that sort of set it up for, okay, it's the courts actually have to resolve this.
Is this, David, to be someone who did not do well in criminal law, so patient with me here, is this really a decision between the right of the public to be protected from the defendant, or the right of versus the right of the defendant to have access to reasonable bail? Is that kind of the balance that we're talking about? That's the way the propositions tended to frame it. The California Constitution, it somewhat reads the same way. So this is an instance of the public's concerns largely dictating the way California Constitutions reads. The big, oh God, Zoom just popped up in front of my screen. So the big distinction is between Article 1, Section 12 and Article 1, Section 28. The question is whether bail is an absolute right that's granted to criminal defendants with 3 narrow exceptions, or whether bail is discretionary and public safety is a primary consideration. So it's either an individual right or a public safety issue, kind of as you described it. Good news and bad news. Humphrey is a major decision, but it only answered one of the 2 big questions. It left the other one unanswered. The big question that Humphrey answered is whether cash bail is unconstitutional. The court held that pretrial detention based solely on a person's inability to pay is unconstitutional. So the upshot here is that trial judges, when they're making bail determinations, they have to consider ability to pay. And, so in the past, inability to pay, it didn't matter. Away you go. Right. Bail is $100,000. Well, I don't have that. Okay, well then, And that's the argument of those who are kind of against, who want this to be a consideration. They're saying that poor people often can't afford bail, and means they're going to cut a deal, even though they claim that they're innocent. They'll cut a deal and take guilt on a lower charge, just to get out earlier. That's the argument why bail should be associated with the person's ability to pay. Yeah, and Humphrey arguably is not. It is important, but it's arguably not, completely novel. There's a U.S. Supreme Court case from 1983 called Bearden versus Georgia, where the U.S. Supreme Court held that imprisoning an indigent probationer solely for failure to pay a fine violated due process. So, arguably the takeaway from Bearden is that mere inability to pay should not result in you going to prison or jail. And that obviously applies in the bail context. I think most public, I think would agree that it's really the risk to the public that person poses as to how bail should be decided. Not do they have the money to pay bail, but what's the risk to the public? Yeah, exactly. And so that's one of the nuances about Humphrey is when it came out, the news headlines were all about Humphrey says money bail unconstitutional. Well, the big caveat to that is that even the absolute right provision. So between the 2 California Constitution provisions, the one that I think governs and that the California Supreme Court leaned on here, which is Section 12, even the one that says you have an absolute right to bail, still has 3 exceptions in the category of public safety. So Humphrey doesn't stand for the proposition that everybody gets out regardless of ability to pay, period. There's an additional consideration. Okay, even if you can't pay, we can still require you to bail or provide other non-financial sureties if there's a public safety reason to do so. But if there's if there's no public safety reason and you can't post bail just because you don't have any money, then we shouldn't be having people sitting in jail for no reason. Yeah, I want to get some questions.
Yeah.
Victoria, you might want to come on, unmute yourself, because while I really enjoy pithy questions, yours is so pithy, I'm not sure what exactly your question is, because I don't want to mess it up. So why don't you go ahead and just ask it?
Okay, thank you. I asked it a while back, so that's why it's out of context at this point. But first of all, I appreciate the conversation. Thank you for having us here. I am a public information officer with one of the larger school districts here in the Central Valley. And you piqued my interest when you were talking about cases that haven't made it to the Supreme Court yet. And I'm curious if you see that trend changing this season, especially with the impending inoculation mandate.
By trend, you mean the California Supreme Court not reviewing pandemic restrictions?
I mean, by the Supreme Court having to weigh in.
I wouldn't phrase it like that. Well, two things. One is that you mentioned, I think you used the phrase like this season, or Mark uses the phrase this term. Minor issue is that the California Supreme Court doesn't operate on a term schedule like the U.S. Supreme Court does. They operate year round. So it's true that U.S. Supreme Court has a term. It starts in October of every year. California Supreme Court doesn't. They don't view their schedule sort of seasonally. So the question of whether pandemic restrictions are going to come up ever on the California Supreme Court's docket, I think people are still going to present them. Me personally, I feel like the likelihood of, or the frequency of those things getting petitioned for review of the California Supreme Court is going to decline. Pandemic looks like it's kind of starting to peter out or fade out, or at least turn into something more endemic. So I think the justification and the rationale and the necessity for the emergency orders is waning along with it. So as the pandemic wanes, so do the orders, and so do disputes about the orders, and so do requests for the court to look at it. And at some point, it's going to become obvious that even if something is, sort of on the docket, teed up and ripe for review, the issues that underlie it have the facts on the ground have changed, and so there's kind of no point in proceeding with the case anywhere.
The other thing you could argue too is that OSHA, federal OSHA preempts Cal OSHA, right? If the federal standard has a standard, and they're arguing about the emergency temporary standards that federal OSHA is implementing under COVID, that's a federal issue. That's going to go through the federal courts. It's not going to go through the state court. So maybe they'll all focus on the federal courts with what federal OSHA is doing. Yeah, there's definitely some things that are as Mark said, clearly federal issues, and so California Supreme Court obviously is going to defer to or let federal courts handle those. Something else that pretty easily can get resolved at the lower courts in the California Supreme Court, I suspect we'll see very little reason to get involved in, is disputes over vaccine mandates. It's very clearly constitutional and lawful. So if a California Intermediate Court of Appeal rejects a lawsuit complaining about a vaccine mandate, there's no reason for the California Supreme Court to take that case. Okay. Alex, you also asked a question, and since we have a little time here, if you want to unmute yourself and go ahead and ask our speaker, go ahead.
Thank you so much for recognizing me, and thank you so much to our speaker. My question is similar to our host's earlier allusion to the partisan makeup of the court. I know there's a lot of attention on the national Supreme Court about how politics plays a role, but I'm curious if, as a result of COVID and just new attitudes on hot button issues, if the risk is greater or if the opportunity is greater for the court to be politicized, such as people paying more attention to retention elections and putting more PAC money in campaignings and retention elections.
We talked about this a little bit earlier in terms of, whether, people analyzing the data, people like me, see partisan behavior on the California Supreme Court. It's very obvious in the past. It's very obvious that it's absent now. California Supreme Court has gone through some pretty contentious retention elections. For people as old as me and Mark, 1986 really jumps out. But 1986 arguably is an outlier. It's the only example of its kind. There have been many other I don't even know if I want to call them attempts, but, people have made noises about like actually recalling or impeaching or just, not voting to retain California Supreme Court justices. And other than 1986 being the big outlier, they've all failed pretty miserably. So to me, that means that, in the grand scope of, our history since 1849, the California Supreme Court has been consistently non-controversial enough to not draw serious attention to politicize it. Again, leaving aside the points that I made about the 60s and the 80s.
The only caveat maybe, David, that we can make with this is everything now is politicized. And so maybe before would have been shrug your shoulders, no big deal. Now there's a political aspect to something.
No, I that wasn't why I was shrugging.
That was me shrugging my shoulders.
Yeah, no, I was doing it too. And, so as much as I don't fully embrace the narrative that our politics is so much more or unusually polarized. There was a guy in Politico, I forget his name. He recently had a really good article explaining that the period of comedy in the middle of the 1900s is arguably an outlier. So to say that our politics is polarized now, that's just to point to literally any other point in U.S. history other than the middle of the 1900s, when people actually got along for 5 minutes. So, it's not like, a J curve or a continuous, exponentially increasing, like, oh my God, things are getting worse and worse. No, it's kind of always been like this, except for the middle of the 1900s. And, the other point that I'd make is that the California Supreme Court, the California judicial branch, like they go to some lengths to consciously try to keep themselves not above the fray, but out of the fray. It's the judicial role. They're a non-political branch. They generally don't have policymaking responsibilities. And when policymaking responsibilities are thrust on them, they try to stay out of it to the extent they can. But that said, I was talking with one of the justices recently who appeared in my class, and I asked her about the voters. So like directly to the question that our colleague just asked. Former California Supreme Court Justice Otto Kaus once described it, his retention elections as the crocodile in the bathtub. You try to ignore it when you're shaving in the morning, but it's there, and it is kind of, it's there. So I asked the justice who beamed in my class about it, and she was very candid about it, because she had gone through a retention election herself not that long ago, and she had to actually sit down and think about it. Like, is this affecting me? Am I, is it affecting my work? Am I trying to write around this to, not cause a problem for myself? And I think the justices, broadly speaking, they're very conscious of the imperative that they stay neutral, out of politics, and maintain their role as the judicial branch. So it may very well be that, groups of voters may try to politicize the court. They may try to take runs at individual justices. I'm sure that stakeholders are lobbying Governor Newsom right now, because there's an open seat. Justice Cuellar just left. So I'm sure that people are lobbying hard to get their person appointed to that spot. And I'm sure that some of those people, are doing so for nakedly partisan reasons. But I think governors have been pretty good recently about not appointing people like that. Like everybody who's gone on to the California Supreme Court recently has received universal praise, and they've conducted themselves in a decidedly nonpartisan manner since they have been on the court. So, so I agree with you. Like I've spent a lot of time looking for partisan behavior on the current California Supreme Court. It's hard to find.
Thank you so much.
Well, yeah, let me reiterate what Alex is saying. Thank you, Dave, for being with us today. I really appreciate your insights on this last year in the California Supreme Court, and we'd love to have you back next year.
Be happy to.
Thanks everybody for joining us.